Awesome. Okay. So hi guys. As Dan said, my name's Martha. I'm gonna be doing today's workshop. In particular, I'm going to be doing a workshop on international law. There are some usual caveats that I think are maybe worth stressing, and some that are maybe a little bit topic specific. Firstly, it's just a bit of general housekeeping. Dan is correct. I won Euros last year. I'm DCA for Copenhagen Euros. I'm CAing Dutch EUDC as well. I've been debating for 5 years. I've been speaking and judging. So I was on the grand final panel for the last Worlds. I also speak, but a bit less these days. But I'm also someone with a law degree, so I am by no means an international lawyer. I'm not an expert in international law specifically, but I have done some of it in my studies, of course, across the course of my undergraduate degree. I'll be doing more of it for my master's degree this year. And in general, I have a bit more of a grasp and an interest in law than probably the average debater does. In addition, because I work in the courts in Ireland, so that means I see a lot of things quite up close. Maybe the second thing is just the usual caveats to apply, which is having said all of that, I'm not an expert, which means I might make some mistakes. I also might say things which you may not agree with, or which you might take to be in some way indicative of my political opinion. I guarantee they are not. If I say anything that has sort of a relation to politics, it's not because it is a thing that is my opinion or that I believe is like absolutely true, but it's because it relates in some way to international law in a way that I think is helpful for the frame in which you view this kind of topic. The third thing I'll say is that there are some terms in every field that mean similar but distinct things. And in international law, I think the most critical of those is the word nation, the word country, and the word state. The reason I think that that's somewhat important is that they do all mean different things, but people use them interchangeably. And certainly I will end up using them interchangeably across this presentation as well. When people say a nation is a people who inhabit a particular country or territory. And the word people in international law also has its own meaning. So it is a group who are united by a shared and distinct ethnicity, who have a shared language, a shared culture, a shared history, or in some other way are kind of, in sort of a nebulous sense, are identifiably a people. And then that they inhabit a particular country or territory. So, for example, we would say Catalonia in Spain is a nation, Northern Ireland is a nation, Palestine is a nation. These things are definitively true because there is a people there who are united by those characteristics who inhabit a very particular country or territory. When we talk about a state is an organized political community with a permanent population, physical territory, and effective government, which means a government that actually is able to do stuff, not just one that is like a puppet government that has no real power, and the ability to enter into relations with other states. So, for example, Vatican City is a state, even though it's incredibly small. It's only like it's less than half a kilometer squared, I think 0.44 kilometers squared, but it meets all of the criteria to be a state. It's an organized political community. It has a permanent population. It has a physical territory. It has an effective government, like the government of Vatican City does rule Vatican City and is able to pass laws and make sure people follow those laws. And it has the ability to enter into relations with other states. But Antarctica is not a state because it doesn't have a permanent population. It only has people who visit, scientists or tourists. You would never have enough of those criteria met for Antarctica for it to be a state. It also doesn't have its own effective government. It doesn't have, so it lacks that, it lacks a permanent population. And with that, I guess it lacks the ability to enter into relations with other states, but it's not a state, basically. Similarly, Catalonia isn't a state, Northern Ireland isn't a state, and Palestine, by the specific definition I'm talking about, this one of what constitutes a state and gives you statehood under international law, is not a state, even though they're all nations. The reason I think that is important is because the state is the actor of international law. Can you see? Sorry, has that not gone ahead? Oh, okay. Sorry, there should be. Let me try fix something. We had moved on to the second slide, in my view. This is where we should be. Thank you for flagging that. But the state is the agent of international law. So it is the actor that enters into various agreements with other states, that enters into governance under, things like the United Nations, international organizations like that, that engages in the kind of things that are governed by and are part of international law. And then the word country means a nation or a state, which is kind of unspecific, but maybe useful to know because for the most part, I think on every occasion I can think of, if I use the word country in this presentation, I will mean state, but it is useful nonetheless to clarify the difference between them, I think, when you're going to use language like this. So we're going to cover, broadly speaking, two things in this presentation. The first is we're going to cover what is international law, what does the term refer to, what do we mean when we say that we're talking about international law, and the second is, does it work? And I guess, in what senses does it work? When does it work? What makes it work? So, part one, what is international law? There are a lot of definitions you might hear for international law. One that I like, that I was sort of found when preparing this presentation, is the Oxford English Dictionary's one, which is that international law is a system of rules that is established by international agreement between countries. There are three parts to that definition that I think are useful. The first is it's a system of rules. So there are quite a few things that fall under what we're talking about with international law, various treaties and agreements, some things that are maybe not binding, like declarations or guiding principles that you get released, court decisions from various courts, some of which, might affect all countries or most countries, some of which might be very regionally focused. But all of them are rules that exist and kind of overlap with each other and interact with each other, but aren't necessarily organized in a hierarchical structure the way a national law in one country would be. So we have a lot of rules that come with international law. They're not necessarily all one will dominate another and always be the one you go with, but it is a system of rules ultimately, like most legal systems. The second is that it's established by international agreement. So one of the most important things when it comes to international law is state sovereignty. I'll get to this a bit near the end of this presentation, but the idea of state sovereignty is that every state is the only entity that has the right to rule over that state. So you can't be coerced into signing a treaty or agreeing to something. You can't be engaged with by force by another state. That's not allowed. They can't take over your state or economically coerce you into taking certain actions. The reason those things are wrong is because only a state like Ireland, they're the only ones who have the right to rule that state. So therefore, that doesn't only affect the fact you can't be forced into anything, but it also means that when states engage in international law, it only applies to them if they consent into it in the first place. So the rules that exist weren't imposed externally by anybody. It's not like in a national system where you might inherit it from a previous system, or it might be decided on by your government who are able to make sure you follow those rules. These are rules that countries agree to and then agree that they will follow into the future, which means it's established by international agreement and it's maintained by international agreement in a way that isn't true of other things. It only really applies to you. International law only applies to a state when they have opted into it in the first place. And the third thing is that it's between countries. So again, it's not externally imposed, it's not top-down imposed onto countries, but all of the laws that we're talking about have been decided on and agreed to by countries between countries. So even if you're talking about something like the United Nations, all of the countries in the UN have consented to be part of the UN and to be affected by the things the UN does. They have consented, if they are abiding by a certain treaty, to have that treaty affect them by signing it and ratifying it and then ultimately implementing it into their domestic law. Which means that even at the level we're talking about global organizations, ultimately individual states and countries are the ones who opted into those organizations. And in many more cases, we're talking about smaller groups who have decided on laws, be it like bilateral treaties between two countries, multilateral treaties between more than two countries, or the kind of things that an intergovernmental organization like the UN can do. Ultimately, they're all done because countries choose to do them. And therefore, countries and states are the actors who are involved in it at every point of international law, and the actors who choose to sort of get affected by them. But usually when we talk about international law at a slightly more specific level, we are talking about three different things. That is, one, agreements between countries, two, international governing bodies like the United Nations, and three, international courts. There are a couple things on international courts that we might mean, I'll get to that, but we are usually talking about one of those three things. So what do we mean by agreements between countries? There are basically two kinds. The first is a declaration, which is an agreement between states that is not legally binding. That's something maybe states agree to, but it doesn't bind them to do anything. They don't have to implement it into their own law. It doesn't really force any obligation onto them. It's just an agreement states have made, but it doesn't really translate into law that affects how states have to behave. And the best example of this is the Universal Declaration of Human Rights, which, despite being one of the most well-known human rights documents that exists internationally, isn't actually a treaty and doesn't actually have binding weight the countries have to follow. So that means that we have this document, and it does say, we respect and we acknowledge various different human rights that exist that didn't exist prior to the Universal Declaration of Human Rights. But that document isn't a treaty, and therefore it didn't introduce any obligations on the states that signed it. They didn't have to do anything, they didn't have to recognize anything in their own national law as a result of it. It didn't impose anything on them. By contrast, we have conventions or treaties. And there are two different kinds of conventions and treaties. The first are bilateral treaties. That is an agreement between two states that is legally binding. And usually, when you compare them to multilateral treaties, they're more detailed or they involve stricter obligations than multilateral treaties do. The reason for that is because if two states sit down and they decide that they want to, make a trade deal, they want to have some kind of free trade agreement or some kind of shared defense pact agreement, or they decide they want, some kind of agreement that makes it easier for members of one state to get visas to the other state, something like that. Then you have both of those countries very much being a part of the document that they're deciding. They'll probably want a certain number of things from the other state, but they'll also be willing to give up a certain number of things or agree to more strict obligations because they've had a lot of involvement in writing that document and because they can very directly see the benefit to them of being involved in it. So there are a lot of examples of bilateral treaties, and I don't think many of them are that well known in the sense that various countries have multiple treaties that affect them like this. One example is the UK-Australia Free Trade Agreement, which was signed in 2023. That's just one that makes various relations between those two states a lot easier, including Australia, for example, makes visa restrictions a bit looser for UK citizens. So there's something called the working holiday visa in Australia. It basically means that you can get a visa for a year, but if you want to renew it past a year, you have to do 3 months of mandatory, usually manual labor for every year that you are there. And therefore, when you've done that, you're allowed to get a second one, basically. But if you're a British citizen or if you apply under a British passport, you don't have to do the work requirement to be able to continue getting working holiday visas. So that's something uniquely available to UK citizens as opposed to other citizens who can get that visa because the UK and Australia have signed a number of agreements that give benefits to both of them, one of them being that free trade agreement. The second kind of convention or treaty we can talk about are multilateral treaties. And that's an agreement between three or more states that is legally binding. They usually, in turn, tend to be a little bit less detailed than bilateral treaties in order to convince countries they should sign on to them and ratify. So that might mean that they have a lot of aims or a lot of principles, but they might not actually require as many obligations on states because the people making the treaty or the states involved in pushing it are very keen to have other countries actually sign on. So there can be some level of mutual benefit in whatever the treaty is trying to do. So I have three examples here, which are all a bit different. The first being the United Nations Charter, which basically sets out all the things that are allowed versus not allowed in the view of the United Nations. The second being the Paris Agreement from the mid 2010s, which was about environmental law basically, and various obligations on states to try and stop the continuing slide of climate change. The third being the United States-Mexico-Canada Agreement, which replaced an earlier trade agreement between those two states, which was called the North American Free Trade Agreement. And that is a trilateral or a treaty between three states, which basically lets them have trade benefits between the three of them. We have a question?
Yes, so when you say it is legally binding, how exactly is it legally binding?
In the sense that once states sign it, they are taking on an obligation to actually implement that on themselves. So when you take something like the United Nations Charter, signing the charter means you are taking on the obligation to follow it. And that means both that you are committing to actually follow it and maybe entrench the things it has in mind, principles or rights or whatever, into your own domestic law. But it also means that you are agreeing to be bound by whatever punishment or enforcement mechanism those documents might have for if you don't comply. So in certain trade agreements, I'm not an expert on trade agreements, but with the USMCA, if one of those states stopped going along with their obligations under that treaty, they would no longer be able to benefit from the other states. Like the other states could then go, well, you're not following this anymore, so we don't have any obligation to give you favorable treatment anymore either. And then the deal ends up falling apart. What I mean by not legally binding, or when I'm talking about declarations, is that ultimately, even if you sign that treaty and you ratify that, so sign that agreement and ratify that agreement, it doesn't impose any requirement on you for how you have to behave as a state or what laws you have to end up implementing yourself. So that's kind of the difference between the two in terms of what those things mean. Irina?
Yeah, this might be a slightly technical question or maybe ESL question, but what's the difference between countries signing and ratifying these
This,
things?
this is a good question. Essentially, the difference is it is quite international law specific, but signing it would be I endorse this. Ratifying would be I endorse it and it applies to me. So you do have cases where countries sometimes sign a treaty, but they don't ratify it. The US has done this with a couple of big treaties. I can't remember off the top of my head, but it would mean maybe when it's being agreed to, they endorse the sort of ideas behind it, but it's not until they ratify it that it actually affects them. States will do both, though, and in that order. So the reason I write sign and ratify is that that's just the process states follow when it comes to international agreements before they end up applying to them. But there is a distinction between the two. In most cases, states do both with an agreement. They'll sign it and they'll ratify it, even if there's a slight delay between the two. So if you take like an agreement like the United Nations Convention on Civil and Political Rights, that's one of the actual treaties that enshrines certain human rights. I think there are very few, if any, countries that have signed it but not ratified it. I think it has been ratified by almost all, if not all, of the states who have signed it, which means that they are committing to follow those UN rights as they're outlined, to implement them in their national law, things like that. But if you were just to sign it, that would be something of an endorsement of those kinds of rights, maybe the idea of having a declaration of that kind on those areas, but you wouldn't have ratified it. So it wouldn't have gone into your national law. You're not taking it on yourself to follow it. You're not taking on yourself to really do anything and be bound by it in any way. Hopefully that is clear. So the second thing that we talk about when we talk about international law is international governing bodies. You'll also see them called intergovernmental organizations or IGOs some of the time, but we're talking about the same concept, which is organizations that are between various states, entered into by consent of those states, and where states choose to be members of them, so they are benefiting from membership, but also bound by the decisions, maybe punitive measures that those organizations might organize, also by any rules that they might come up with. So a rake of examples here. The United Nations is one. It is one of the biggest in the world. The European Union is also an international governing body. You have the Economic Community of West African States. That's just, it's kind of what it says in the tin. It is an intergovernmental organization for West African states. It's both economic, sometimes political, sometimes, but rarely military, but primarily economic. And then the World Trade Organization, which is the kind of organization that can impose rules on people and dictate regulations when it comes to trade. With these, and again, drawing back to state sovereignty being very important, these organizations are entered into by consent of countries. So if you are not a member state of the European Union, you won't benefit from the things the EU offers. You won't get the freedom of movement for your people or for your goods. You won't get the, benefits of free trade that happen within the European Common Market. But equally, you won't be bound by EU law and regulations in the same way that EU member states are. So there are, I guess pros and cons is quite what I mean, but there are benefits to being in one of these organizations. There are also some constraints you are taking on by that membership. An agreement to be bound by sanctions if you don't follow the regulations, an agreement to follow those regulations. I guess just conditions on being able to access those benefits. What these governing bodies also do is they create rules and regulations for certain things which are legally binding. In some cases, they automatically are binding on member states. So EU regulations, there's a couple of different areas of EU law. It's not very important to know the difference, but one of those is EU regulations. And EU regulations are the ones that automatically are binding on member states. As soon as an EU regulation comes out, you have to implement it into your domestic law. That is an obligation you take on by being an EU member state. In other cases, member states have to sign and ratify the agreement before it applies to them. So UN treaties are a big example of this. Equally, I'm not as familiar with other organizations, but anytime they're doing something that is a treaty or a convention, then you have to sign and ratify it for it to be able to apply it to you. What is interesting also with these, though, is that member states are involved in the process of creating those laws. So EU member states don't just like join the EU and then a dictatorial force makes them follow all of these rules and regulations, even though it's not in their interests. What actually happens is that they are involved in the process of creating those laws. Every EU member state has representatives in the European Parliament. They have involvement with the decisions of the European Commission and the Council of the European Union. They have the ability to feed into the process by which laws are made. And then in turn, when those laws are made, they apply to them. So states are involved. It's not just forced upon them, but it is a case that there is something more like a national government, even though it isn't a national government, that is able to make laws with the consent and with the input of states. And then those laws and rules apply to states. They are sort of bound to follow them by virtue of being a member state of that body. And the final one that we talk about most of the time, we talk about international law. And one of the ones that comes up in debates the most would be international courts. I would say there are broadly three kinds of international courts. And I'll get to this on the next slide, actually. Although basically it would just be there's the ICJ. There's criminal courts like the ICC, but also individual tribunals like the ICTY, which is the International Criminal Tribunal of Yugoslavia, and the ICTR, which is the International Criminal Tribunal of Rwanda. And then you have human rights courts. The European Court of Human Rights in Strasbourg is the one you're most likely to be familiar with. But other continents have also had them, and a lot of their case laws historically fed into one another in kind of a mutually beneficial way. So you have the African Court of Human and People's Rights, and you've also had the Inter-American Court of Human Rights. And all of the case law from each of those three courts has often somehow, in some ways, been involved with one another. Like with the international governing bodies, international courts are entered into by consent of countries. So countries do have to decide that that court applies to them. And that means that the decisions of those courts don't have any impact on states who have not agreed to them. A good example of this would be the United States has not ratified the document, the Rome Statute, which gives the ICC its jurisdiction. And therefore, the United States isn't bound to follow the International Criminal Court or decisions found by it. And the International Criminal Court doesn't have jurisdiction or permission to operate in US territory or to make decisions that affect the US or US citizens as an actor. Yep. Dan?
Oh, yeah. You said something which I thought sounded quite interesting, which is the idea that the case law of these different human rights courts fed into each other. How does this like concretely look? Because for me, it sounds really weird where if I'm like bringing a case to the ECHR, I could say, oh, but there's this, I could cite case law from another court.
It's most analogous to living in, I'll use a common law example because I'm from a common law system. I don't think the Netherlands is a common law system, so really sorry if it doesn't make sense. But common law systems for domestic and national legal systems are ones that require and rely upon precedent and past case law. Ireland is a common law system. The UK is also a common law system. America is a common law system. Canada is a common law system. If a case was to come before the Irish courts, which was really unprecedented in terms of Irish law, we just didn't have case law in our system to tell us how we should decide it. We would look to other jurisdictions, like the ones that I've listed, also Australia, and we would look to see if any similar cases had arisen there and how those cases had been decided. And we would use that information not necessarily as being binding on how we should decide things, but as being informative of a pathway that we could take and a pathway that a similar court in a similar situation did take. And the reason I use that example is because what those three human rights courts have done is that they have dealt with somewhat different situations to each other. I'll try to ground this a little bit more. One of the situations in the Inter-American Court of Human Rights is that a lot of cases that came before it historically have involved people being denied the right to truth. So that being that you had dictators or authoritarian leaders who suppressed kind of truth-seeking measures either during or after authoritarian regimes. Broadly speaking, the case law of the Inter-American Court of Human Rights was pretty pro the right to truth. So they would have found that wrong. They would have tried to take actions to, I guess, say that that was wrong, discourage states from doing it, encourage states to have truth commissions, some kind of criminal investigation if possible, but if possible, to fulfill the right to truth and have that information come out there. The European Court of Human Rights has affected, a different set of countries that have had a different set of things happen over the past 100 years. And that means that they haven't had necessarily as many states that were coming out of authoritarianism, where people wanted to know about things that had happened during a period of time, but were denied the truth of doing so. But when they did, there was one example of a Croatian case. I can't remember the name off the top of my head, but there was a Croatian case where someone was seeking, I think, on an individual level, the right to truth. And they were alleging they'd been denied the right to truth within Croatia. I believe this was during the Yugoslav wars, although I'm not 100% certain. And while the European Court of Human Rights wasn't bound by the decisions of the Inter-American Court of Human Rights, the fact that the Inter-American Court of Human Rights had a very deep case law and a very deep set of cases where they had examined cases of this nature and they had given their judgments and written out their reasoning, that was something that was quite informative for the European Court of Human Rights. And I don't think they made exactly, I don't think they came to exactly the same conclusion. I think they had a slightly different read on how the right to truth should apply. But that concept, there was no case law in the European Court of Human Rights to decide what the right to truth was or what it should look like. And so then they were able to inform their perspective by looking at what another human rights court had done, by looking at maybe the similarities and differences between the legislation they were both applying and seeing what was relevant for their situation in a way that they wouldn't have been able to do if there weren't other courts looking at those situations. So that's what I mean when I say they kind of feed into each other, which is they're all a little bit different and they have slightly different philosophies and they're based on different treaties ultimately. For example, the African Court of Human and People's Rights is really interesting because it's based on the only human rights treaty in the world that has recognized the concept of a people's rights. And it's quite robust relative to other things on that. The idea that a people, as in like a group who are recognized as the people in international law, have the right to not be, they have the right to govern themselves and the right to not have governance forced upon them. So from that perspective, they think military coups are super wrong. That hasn't necessarily arisen in other places, but it's not always been necessary to either because the same circumstances were applying. But from an informative perspective and from seeing how you can approach different situations, those are the ones where those courts have been able to look to what the others have done and then come to a decision on similar cases themselves. I hope that answers that question. The only other thing on this slide I just want to say is that the jurisdiction or the area in which these international courts apply and the things that they're able to rule and decide on are provided for explicitly by treaty. And therefore, if you enter into, consenting to that court applying to you, that means that you've signed and ratified the treaty which gives it its power. So for the ICC, it's a document called the Rome Statute. For the ICJ, it is both the UN Charter itself, but also another document called the Statute of the ICJ. For the European Court of Human Rights, it's the European Convention on Human Rights, and so on and so forth with other courts as they exist. You are consenting to be affected by them in that way. The type of cases that those courts might deal with varies a bit. So firstly, when we talk about the ICJ, the nature of this case is state versus state. And broadly, the ICJ covers interstate disputes, primarily historically over borders, but also with compliance with international law, in particular things like genocide or other crimes against humanity the state might be responsible for. Those are things that often have gone to the ICJ, as one state brings another state to the ICJ to have the court decide whether or not they have broken those kinds of international laws. But you also have a lot of cases where it's just interstate disputes where there's some disputed territory, some peninsula, or like a corner that two states are trying to claim. And the ICJ is able to determine who it belongs to and why it should belong to them. Or if one state has been, impeding on another state's territory or not. They're pretty good at being able to determine if that's happened and what should happen as a result of that. The second type of case and type of court we might talk about is international criminal courts. And primarily here, I do mean the ICC, but the international criminal tribunals are also relevant here. The structure of those cases, when you look up the case, is that they are prosecutor versus the individual. So instead of being state versus state, you have the prosecutor of the International Criminal Court is one of the actors in this case, in the title and in the trial itself. The other party is the person who has committed some kind of grave violation of international criminal law that has had them brought to the ICC. And already this is a bit different to the ICJ because the actor we're talking about as being affected by the ICC isn't a state, it's an individual. Historically, it is like the leader of a state, people who have been responsible for huge amounts of damage. But the purpose of the ICC and its the corollaries of the tribunals isn't to cover sort of disagreements between states over borders or over who's complying with and interpreting international law correctly. It's holding individual offenders accountable for very grave violations of international criminal law. That therefore means it's more like criminal law in a domestic system where you need to have the actus rea, the bad act, essentially, mens rea, the guilty mind. You need those things in order to prove a person has committed a crime in international criminal law. But also where it differs from domestic systems is firstly, it follows a thing called the principle of complementarity, which is basically it's supposed to be a court of last resort. It doesn't act on these things until the domestic court system that person would be affected by has either been exhausted, like you've tried and it hasn't been able to see it happen, or is unable or unwilling to prosecute that person for the things that have happened. Maybe it's too corrupt, things like that. But the second is that it is individual. So it is only for very, very significant and severe kind of violations of criminal law. So it's not about things like murder or things that you really could or would prosecute at an individual level. It's for like huge crimes against humanity or ones that affect huge amounts of people. And therefore, for those two reasons, the number of cases the ICC actually sees through are very small. And when they choose to see them through, it's often like the top dogs, the people who are most responsible for horrendous things. Those are the ones that they tend to prosecute for international crimes and international criminal law. The third thing that you might see is in human rights courts, the structure of decisions for those courts or the parties to those trials is that they're individual versus state. So individual citizens hold states to account for violations of specific human rights treaties. The European Court of Human Rights is following the European Convention. The Inter-American Court of Human Rights is, I think, following the Inter-American Charter of Human Rights or something to that effect. And the African Court of Human People's Rights is similarly following a document that has a similar name to that, but that I cannot remember at this time. But that means that there are specific sets of rights that have been outlined that the parties to those treaties have agreed to. And what happens to human rights courts is individuals bring a case to those courts, claiming that their state or the state maybe that they're living in, the state that they've been wronged by, has broken those rights, and they're seeking for the court to determine whether or not they violated those rights, and if they have, what the outcome of that should be, how that should be handled. So that means that they also have a somewhat specific domain, which is things that fall under their specific treaties, but also the relationship of who is involved in the trial is you have an individual person taking a state to the European Court of Human Rights or another international court of human rights in order to get a case to actually be moved. Yeah, Roald?
So for the ICC, let's say someone is convicted, who then carries out the punishment?
The ICC essentially has the ability to imprison people in The Hague, so that would be the punishment. But to a large extent, also the largely public nature of it, how horrendous the crimes are, the precedent of how they're being handled and how the person's legacy is affected, are, I guess, the kind of big ticket differences in punishment that you would add on to just a life sentence for the kind of terrible things that you might have done if you are found guilty. So I guess there is a sense in which it's not maybe on a practical level that different to being prosecuted within your own state. And in that's kind of a feature, not a bug, because it is trying to hold people account for criminal activity. It just so happens that the crimes are much bigger and that domestic courts haven't been able to do it. And so then when people are found guilty and prosecuted by the ICC, essentially they get locked up in prison, not dissimilarly to how they would in a domestic system. I said there were 3 things that we talk about. Yeah, sorry, Alana?
I just have one question about what triggers the investigation of a court or which person, especially with the ICC, because I think with the International Criminal Courts, you can have a referral by a national court, if I understood it properly.
Yeah, so that's one thing that can happen with the ICC. The other would be, with the ICJ, one state has to take another state. It doesn't have to be because they are in disagreement over something. It can be, especially with border disputes and things like that. But it can also be because they don't believe the other state is complying with a particularly critical part of the UN Charter or another piece of international law that ICJ covers. You would see that the most in genocide. So things like South Africa taking Israel to the ICJ isn't because South Africa is directly involved in the conflict in Gaza, but it's because I think it's Article 9 allows states that are party to the Genocide Convention are allowed to take other states that are party to the Genocide Convention to the ICJ if they think that they're violating the Genocide Convention. So that's the kind of two ways you get the ICJ. Either you guys actually disagree directly, or you are allowed in international law to take them because you think they're not complying with international law. With the ICC issues arrest warrants, basically. So they decide, we think this person's really bad, we're gonna arrest them. We think that they should be held accountable. The way they choose it, I'm not really specifically sure on the internal workings that much, but since they follow the principle of complementarity, I would assume they bear in mind whether or not the domestic court system either can or will be followed. And then what happens is states that are party to the ICC have an obligation to follow the arrest warrant and to arrest people who have an arrest warrant from the ICC out for them when they step on the soil of that country. Does that always get followed? Not exactly. We'll talk about it a little bit more later in the presentation, but that is the mechanism by which people get arrested. And then once they're in the hands of the ICC, they start basically being on trial. With human rights courts, an individual person takes a state who has harmed them to the human rights courts. They make an application to the court directly, wanted to take that state to court for the issue in question. I know the European Court of Human Rights best because it's the one, for the continent on which I live. But with the European Court of Human Rights, at least for Ireland, but I think for other states as well, normally you would also have to exhaust, domestic provisions. So if you have an issue with the Irish government for how they're treating you and you believe that they're violating your human rights under the European Charter of Human Rights, European Convention of Human Rights, then you should, in theory, take that all the way up to the Supreme Court. And if the Supreme Court also decides against you, then you can apply to the European Court of Human Rights. It's kind of you're appealing the decision from the Supreme Court to the European Court of Human Rights. But that is generally how the human rights courts work. People try to go through the domestic system. Failing that, they make an application to the court, and the court decides whether or not to take it. If they take it, they assess whether or not that state has violated the human rights treaty that they've signed up to. So that's how all of those different courts get accessed in terms of how people end up going to the court and how different cases end up going to the court. Okay. I did say sort of there's three things we mainly mean when we talk about international law. There is one weird exception, and I bring it up not because it has any bearing on debates in international law, but because partly I think it is interesting, and partly I think it is good to have sort of a framework for how international law functions when you're looking to improve at these things. Okay, so that is something called customary international law. Customary international law is unwritten. It is when international legal obligations arise not because you agreed to a treaty or you agreed to have a certain court or a certain body have the power to make decisions that are binding on you, but because there were established or customary international practices that have existed for quite a long time. There are three conditions for a rule or like a behavior to become customary international law. The first is you need a widespread repetition of similar international acts over time by states. So it can't just be like one or two times it has happened, but it has to be, this is a thing states have been doing over a long period of time to the point that it is a custom, it is a norm. The second is that the acts that have occurred out of a sense of obligation. So it wasn't just that it was a norm, but it was a norm people felt they ought to follow, a norm they felt they should follow. And the third is that the acts are taken by a significant number of states and not rejected by a significant number of states. So that is to say, like there are quite a few states who do follow this norm and do these acts, and there's not a significant number who don't do it. So an example of this, because it is fairly rare, especially now when we have codified and written a lot of our international law, is that before we codified the laws that apply to war in the Geneva Conventions, those were themselves customary international law. The political philosophies behind the laws of war have existed for hundreds of years. They have like theologian starting points, basically. Like they start in Christian theology and sort of end up being laws that affect how war should play out and how you should behave both in starting a war but also during war. But before we codified those things, they were just customs, they were norms that many states followed, that states felt they had some obligation to follow, and that there weren't many states not following. So they still were a form of international law that were sort of binding. It's a very weird area, but it did exist, but they weren't codified yet, so states hadn't explicitly agreed to them. It's a very messy area because, you know, what constitutes a customary international law, but also whether customary international law is binding in certain instances. These things are like highly disputed in international law, but I just think it's useful and maybe interesting to know about to some degree. That having said that, it never comes up in debates. I just think it's maybe useful to know. And maybe to paint a picture as well that international law is in some senses quite weird. There are some strange things about it. There are some strange norms, partly because it's something that has not come about maybe all at once in the way that if you were to start a new legal system from scratch, it might start up all at once and you could build a system that makes sense where everything feeds into each other in a very deliberate and planned way. International law is not really like that. It's popped up in many areas to cover different things, and sometimes those things overlap or affect one another somewhat. And sometimes states are parties to some things, but not to other things. But it's very unplanned. And so you have a lot of different areas of international law, different kinds of international law. The main one, Dan, is that prior to stuff like torture has been codified into international law. So that's why I say it's kind of, it's not that it's obsolete, but it is not as important as it would have been 50, 60 years ago, because a lot of the customs have just now been codified. But before, you know, World War II, the many hundreds of years before that, the laws of war were customary international law. They weren't codified. No one had agreed to them in writing, but they were customary international law in that way. But having said that, they don't come up in debates, just kind of useful to know. Alex?
Yeah, but isn't it also something like that things surrounding like genocide and slavery and piracy and that kind of stuff are considered like illegal by international law even if you haven't like agreed to it? Isn't that also something of customary international law?
I do think so. I am not absolutely an expert in customary international law, but I do think certainly piracy, things like I would say torture as well, prior to being codified at all, were forms of customary international law. And I do think they still have that force in areas, even if you haven't explicitly agreed not to torture people, things like that. They do hold a huge amount of weight still. So I think you're correct. Torture is probably a good example, even though it is codified to some degree. It is a good example of this as well. That's kind of the first part in terms of like what is international law. I guess my endpoint would be a lot of things, a bit messy, but ultimately it's something states agree to, it's something states build, and it's something that is legally binding, but only if you've opted into it and only in a specific jurisdiction of whatever that organization or court or treaty has decided to cover. So, part two, does it work? I think it is quite common for people to say that for the reasons I've suggested, that international law is messy, it is covering a lot of areas, but not necessarily making a coherent big theory, because you have to like consent into it for it to have any weight. Often people say, well, does it really work? It doesn't seem like it works. What I would say, and it's not my original words, but Lewis Henkin, an international law scholar who was American, said, and often gets quoted for this, which is almost all nations observe almost all principles of international law and almost all of their obligations almost all of the time. And I do think that's a useful way of thinking about this, because while it might be that you can think of examples where international law has failed, or you can think of examples where states haven't followed their obligations, have violated human rights treaties and gotten away with it, have, committed war crimes or not listened to the decisions of various courts, that is the 1-2% of cases. 98% of the time, states are following international law and they are following their obligations. And because it's not making news stories or it's not notable that states are following their obligations, we don't really notice it in the same sense. So what I want to talk about now is, what is it that international law does well? And what can you bear in mind for international law doing well? I'm going to talk about 5 things. The first being prevention, the second being collaboration, the third being language and having the language to describe things, the fourth being resolving disputes, and the fifth just being, I think, guidance. I can't remember if that's actually the one I've ended up having the fifth. I guess we'll see. Okay, first one, prevention. In various cases, international law prevents problems from ever arising in the first place. So I think a really good example of this is the Outer Space Treaty from 1967, or as it's also called, the Treaty on Principles Governing the Activities of States in the Exploration and Use of Outer Space, including the Moon and other celestial bodies. It's the Outer Space Treaty. It arose and was created in response to the development of intercontinental ballistic missiles in the 1950s, which could reach target and could reach other states through outer space. That was one thing. The second thing was that in the late 1950s, the early 1960s, America and the USSR had started the space race. They'd started trying to get to the moon, trying to get into outer space. And there were very real and genuine fears that space would become a new frontier, not just for the Cold War, but for other future wars, that it could be a thing that was militarized and a thing that people had to be afraid would also be a place where they could be attacked from. So in 1963, the United Nations General Assembly unanimously adopted a resolution. It wasn't yet a piece of law, but it was we want to make a piece of law, basically, banning weapons of mass destruction in outer space. And then in January 1967, the much more detailed Outer Space Treaty was drafted and adopted after various debates and proposals about what it should look like and what it should include. The key provisions in that have remained true to this day and have stopped significant, honestly, stopped any military activity in space causing issues for people like this. Firstly, it just banned nuclear weapons in space. They were explicitly prohibited. Secondly, it limited the use of the moon and other celestial bodies, so other moons, other planets, stars, to peaceful purposes only. You couldn't put military bases there. You couldn't test weapons in space. Those things were explicitly prohibited. And the third was it precluded or banned any country from claiming sovereignty over outer space or over any celestial body, which means that countries couldn't say, well, the moon is ours. The USSR landed first. The moon belongs to us. Venus is ours. We've landed. We've got our spacecraft there, so it's ours. Or, getting some initial satellite out to space and saying, as a result of that, the orbit of the Earth belongs to you. That was also explicitly prohibited. So as a result of that, while, there are many fears that happen as various current affairs things maybe suggest that the world is not always peaceful, one thing that has stayed pretty peaceful is outer space and is the moon. It is the things in orbit. We haven't had wars taking place over areas of space or in space, and that is actually a pretty significant blessing. It's kind of hard to appreciate how great it is to not be at war or to not be under attack from a certain area. But we don't know what would have happened if nothing had been decided on that. So the fact that states agreed before anything had even happened not to let outer space become militarized has stopped outer space becoming militarized. So that's an area where international law has done quite a good job preventing a bad thing from happening. Another example I would say is NATO Article 5. So that's the article that says if states attack one NATO country, that's considered an attack on all the other NATO countries, and those other NATO countries then required to respond as necessary to protect their ally. You get a lot, I suppose, NATO Article 5 has stopped a significant amount of wars. It's stopped a significant amount of military attacks. It's kind of hard to stress that because when we talk about it in the news, normally we're talking about whether or not Ukraine will be able to join NATO, or if Russia attacks a certain NATO state, is Article 5 actually going to be upheld? But the fact is that huge numbers of attacks that could have happened haven't happened because NATO Article 5 exists and because that obligation does exist. I think one example of where it was a huge deterrent of military attacks in a way that stopped what could have been World War III is during the Cold War and during the Cuban Missile Crisis in 1967, The USA was considering invading Cuba because Cuba currently was hosting or was about to host significant amounts of nuclear weapons for the USSR. But they knew that if they did that, the USSR would have to respond. And what the USSR was going to do if they had to respond, most likely, they would invade West Berlin, because West Berlin was under sort of the jurisdiction of Allied member states, so states that had won World War II. But Berlin was in like the middle of East Germany. West Berlin was then like a pocket of West Germany, very much in the middle of East Germany. So if the USSR was going to respond in any way to the USA invading Cuba, the way that they would probably have to respond, because they can't let that go unanswered, would be to invade West Berlin. West Germany was a NATO member, so if the USSR did invade West Berlin, they would have been at war with every NATO member state, which would have meant a World War III that no one wanted to happen. And the knowledge that that would be the response the USSR would have to follow if the United States invaded Cuba was a huge deterrent from the United States invading Cuba. It forced them to find another solution and ultimately, tenuously, to resolve the Cuban Missile Crisis diplomatically, because they couldn't go along with the option of invading Cuba and risk the USSR invading West Berlin, which would itself mean the beginning of World War III. So NATO Article 5 has also prevented various attacks that could, like, I guess because the threat of global war is so bad, that individual wars or attacks which might have been slightly easier than resolving things diplomatically or might have been convenient for states haven't happened in a way that I think is really good. I suppose one other example of this you could think about, although it's not clear yet how it's going to play out, is that an attempt at this for sure would be regulating AI and things like the EU's AI Act. We don't know what artificial intelligence is going to be able to do in the future, but the fact that international organizations and states have made huge efforts to regulate preemptively how they'll use AI, where they'll be allowed to use AI, what kind of training data you can use, what the purpose of it would be, is an attempt to prevent bad things from happening by trying to preemptively regulate things before they happen in the first place. I don't know if that's going to play out in a way that's effective, but it is certainly an attempt to do so. And that is one of the ways in which international law can and is used for the common good in that way. Rolf?
So how do you use these examples to structurally disprove analysis that leans just heavily on the idea of, but actually international law doesn't work because there's no end enforcer? So basically it's just what countries would like, what's in their own interest at that point in time? Because then these are counter examples, but how do you disprove that kind of analysis?
So I think it's case specific. It depends on the debate and it depends on the motion that you're talking about. But the way I would deploy this most likely is to say often states agree to these things, A, before they have the benefit of not agreeing to them, and B, because other states are agreeing to them. So they take on those obligations before the bad thing happens in the first place. I think then the claim you're making is that if people are saying international law doesn't work, so you could always just like not comply because there's no end enforcer, what happens then? But I would suggest there is, even if not an end enforcer in international law, things don't happen without consequence. And you still have to engage with various other states in various other ways. So it's both true with prevention, that has led to legislation that stopped things from happening in the first place. But it's also true that if you were to break the Outer Space Treaty and put nukes in space, I would posit other nuclear powers would be extremely unhappy about this. And so, firstly, they could also put nukes in space. A lot of the time, the benefit of international law is maybe you can't do something, but other people can't do it either. So doing something that means all of your enemy states or states that maybe just aren't perfectly aligned with you at any given time could also do that thing. The cost of them being able to do it is probably worse than the benefit of you being able to do it. But the second thing is that you could just suffer other kinds of harms from your interactions with other states in other areas. So maybe, your trade deals with other states suddenly aren't, they back out of those trade deals. So you're struggling they might just put embargoes on your goods. You might not be able to export goods anymore to those other countries, which could be a huge source of revenue for your state. It could be that you're not able to, you can still trade with them, but you can't benefit from free trade or shared currencies, whatever. Probably also even beyond other states being involved. I would just imagine if you did something crazy, like if you actually violated a piece of international law no one had violated before, I would posit that most investors in your country would probably get super scared of your government being crazy and pull out a lot of their investments and pull out a lot of their money, which is harmful to your economy in itself, but also it will make people who live in your country extremely scared and unhappy and pretty mad at you. So when you think about the way other people are likely to react to this kind of thing, not just that if they don't feel they need to abide by this law either, that's not in your interest, but also taking this kind of action is clearly controversial, I think you should be able to come up with ways that this isn't in a country's interest in the medium to long term, and the costs of doing so are stronger than the benefit of breaking the international law once. So I would particularly say for things like treaties, especially long-standing treaties, that analysis should be something that's able to work pretty well. But it will depend to some degree on exactly the motion that you're talking about. The second benefit, I think, majorly when it comes to international law is collaboration, which is that international law helps states collaborate to solve global problems as they exist. One example is Interpol, or the International Criminal Police Organization, which, despite popular belief, is not actually itself a law enforcement agency. Like Interpol is not a global police force who like show up at your door. What it is it's an organization that like coordinates between national police forces, focusing on transnational crimes. So they provide sort of training to law enforcement in different countries, and in quite a lot of different countries. It's like over 150, I think. Expertise and knowledge, and just investigative support to be able to investigate things and not have to stop exactly on the border when you're chasing a criminal or trying to find someone who's part of either a crime or a criminal network of this. They focus on transnational crimes. In particular, what that means is they focus mainly on terrorism, cybercrime, and organized crime. But they have a fairly broad mandate of just basically any kind of crime that crosses borders, that, you know, maybe where the person who commits one part of the crime or another part of the crime are in different countries, or where people might be part of a network that crosses different country boundaries, or where the person who's committed a crime can cross between country boundaries. So they're quite useful in that respect. And what they cover can range from crimes against humanity to child pornography to drug trafficking, production, political corruption. I would say less common than the others, but still happens. Intellectual property infringement and white collar crime, because all of those things can cross various borders and would require, if you wanted to be able to catch the people who are committing those crimes, various people in various countries, various law enforcement, working together to find the people who are responsible. A big example would be child pornography. I know a little bit from the work I do in my actual job, which is often Interpol can get a ping that a certain IP address has accessed child pornography on the dark web or on some kind of site that is accessed by people internationally, but they're able to track that certain IP addresses have accessed it. And they can then inform, say, the Irish police or the British police or the French police what the IP address is, that they can then follow up on it and find that person. Otherwise, it'd be quite difficult to do so, because a lot of the like most of that exists on the dark web. Most of the networks who are doing it exist across a lot of different areas, and geographically they're just quite dispersed. So it is quite significantly useful that Interpol is able to catch them because they have a lot of resources to devote to that kind of thing, and they can then give that information to the police of a national country, who can then go find the person who has that IP address. That's actually very useful when it comes to catching criminals and to stopping crime before maybe it gets much broader or much more prevalent, but also stopping crime just being a thing that like you aren't able to attack or affect if people leave your country's boundaries. They're very useful in that respect. So the ability for states to collaborate to solve global problems, or at least problems that don't only affect one state, is very helpful and very, very useful. I would suggest as well, while not solving global problems, trade agreements are also an area where international law helps states work together kind of for the common good. You get free trade agreements where people agree that they won't have any kind of protectionist measures against each other. You'll be able to just trade one another quite easily. Currency unions and things, all of those sort of help states collaborate for the sake of making things better and solving some kind of problem. What I've also put on the slide, and I think is true, is that in theory, the Paris Agreement is an example of this, in the sense of it is an example of states collaborating to solve the global problem of climate change, which clearly doesn't stop at the border of any kind of country, even though it affects certain countries more than others. The reason I say in theory is because I think it's hard to say with any level of certainty or conviction that the Paris Agreement has been a fully successful piece of international law, or that it's been something that states have always stuck to their guns on and always held up their commitments for. I don't think that's necessarily true. But that's certainly the idea behind something like the Paris Agreement. That's the idea that leads into that kind of law. So that's why it exists in that way. And that's something that does drive the creation of various kinds of international law and various kinds of agreements. The third thing I want to talk about is just convenience, which I touched on a little bit in the last slide. But what I'd broadly say is international law creates a series of benefits, not just to individual states, but also to the people who live within those states. So with currency unions, you can have states agree that they will all use the euro, or maybe they'll dollarize and they'll use the dollar, which makes it much easier for them to trade with one another because exchange rates aren't a question mark. You know how much you can buy with your currency in that other person's currency. It's much easier for the planning of investors and stuff because they don't have to worry about exchange rates, which actually get, or like the costs of making exchanges as well, which can get quite high when you're dealing with huge amounts of money. So the ability to plan or invest and stuff, and how likely it is you might set up another branch of your company or whatever in different countries, all of it's much easier if you're using the same currency. So currency unions and the fact that you have to abide by certain things, you have to agree to not massively screw over your country with your monetary policy as a result of it, those things mean that people trust other states will live up to certain conditions and will not be a liability in engaging in a currency union. And then in turn, people get the benefits of currency union, which means that that's good for multiple states. Similarly with trade agreements, you're able to just make trade easier between states. You're able to mean that you can get more products at cheaper prices, that civilians have more choice in various things, but also maybe there are various things that one country can make that another country can't. So having large-scale trade agreements between those countries is often very useful. So their specialization is able to benefit both states rather than just one country having like a bunch of sheep and one country having a bunch of cows and no ability to get the benefits of the other animal because their particular country or land isn't able to look after it well. Another thing I'd say is shared military training, which you get quite a lot. So being a member of NATO or maybe just having a shared defense pact can often mean that like you'll have various NATO states collaborating on their training, and that might be like literal foot soldier training, but also like using the different equipment, using, you know, like their navies training together, their air forces training together, sharing techniques, sharing all of those things. That can also just help states where they might not have the expertise to have this kind of military training on their own, or they might not have the knowledge to use various equipment as well. Being able to train with better armies can just mean that you're more prepared in the event that there is any kind of war, you need to protect yourselves against that kind of thing, which is probably good. Another thing I'd say is freedom of movement, in particular of people. So, you know, the Netherlands is in the EU, Ireland's in the EU. When I come to Dutch comps, I don't need a visa. Partly that's because of Schengen, but Schengen is itself very interlapped with the European Union. Generally speaking, I could move to another European Union country tomorrow. And especially if you live in one Schengen country and you want to move to another Schengen country, you could move there tomorrow and you wouldn't need a visa or to declare anything about moving there. That's an incredibly useful thing. It's also very useful to just be able to go and visit other countries without needing a visa, which is often very convoluted and difficult to get and can sometimes be, you know, denied for quite arbitrary reasons. So having the ability to do that gives people a huge amount of freedom. But it's also in the interest of countries. They can try and get more skilled workers in different countries. They can try to attract more tourists for kind of money and that kind of thing. It's generally in the interest of lots of countries to have freedom of movement. But the way in which we access that is when states agree that they will have freedom of movement between those states. And even within that, there are states that give preferential visas to other countries. They're willing to give visas maybe only to skilled workers or only to people of certain nationalities, which is not always great. But if you're one of the special nationalities or one of the people with that job, it's pretty good for you that because of an agreement between two states, you can move to a sunnier or better workforce area or a richer country or whatever in a way that is beneficial. So while there is definitely a less fun side of the coin with visas and stuff, the fact that there is the ability to have freedom of movement is mainly only possible because we have international law and states are aware that they could have people move from those other countries, they agree to it, and then people like us are able to benefit from it. So that's pretty good. And the final two I have here are just development aid and loans and humanitarian aid. So development aid and loans, if you take an organization like the IMF or the World Bank, when they give loans to countries to develop, those loans come with conditions. And those conditions are quite important because the countries that are giving money into those organizations want to make a return on their money. They'd like it to come back to them at some point. The fact there are conditions that the states that are given money have to follow in order to receive the loans, and they have to keep paying back interest to keep paying back the loan, is what gives those countries, the giving countries, the confidence to believe they will get a return on their investment, and therefore the willingness to give money into those organizations. So the fact that we have those kind of loans only really is possible because there is a system by which rules are created and followed that people trust enough to believe that they will get their money back at the end of the day. Development aid, similarly, I suppose, is something that is able to happen because large organizations can organize it in the first place and coordinate between countries in a way that wouldn't be possible without some kind of organization to deal with them and engage with them. And humanitarian aid as well, in particular when you look at United Nations organizations, for example, there's a huge level of organization and expertise you're able to access as an intergovernmental agency with lots and lots of connections where you can coordinate between countries, get all of their information, get their people and have people on board, and then have the ability to distribute food and medicine and send people into countries. That is made possible by the existence of international law and by international legal organizations. So there are various benefits to countries, but also to individuals that happen as a result of international law existing. And therefore, I would say it's very convenient for the average person that international law does exist. It makes their lives better in various different ways. The fourth thing I would say is that international law does help to resolve disputes between nations. While this isn't to say that every single dispute ends up resolved by international law, the fact that it has the ability to do so is quite significant in, the ability to make sure states' relations can be better and also resolve questions that otherwise there really isn't an answer for. So one example is the ICJ when Cameroon and Nigeria had a territorial dispute. Nigeria and Cameroon are two neighboring countries in West Africa. And in the 1990s, they clashed over Bakassi, which was a peninsula in the Gulf of Guinea that both countries were claiming was their own. They brought the dispute to the ICJ, and in 2002, the ICJ ruled that Bakassi belonged to Cameroon. After a couple of more years of UN facilitated negotiations as to how they were going to go about transferring control and what this meant, Nigeria transferred control of Bakassi to Cameroon in 2008, and since then it has belonged to Cameroon. That is not to say this is the perfect system. A lot of the world's most heated territorial disputes don't ever make it to the ICJ because neither party wants to risk losing the case. But there still have been a number of cases where this has worked, and states have gotten an answer to the dispute that they otherwise wouldn't have. There was also another ICJ case between the DRC and Uganda as to whether or not Uganda was encroaching in and had their troops, I think, in the DRC in a way that violated the DRC's territorial sovereignty. Ultimately, the court ruled that they did, ruled that Uganda had to pay Congo quite a lot of money. And despite not being the richest country in the world, Uganda then did end up paying it. So because I guess countries would like to benefit from those courts possibly looking favorably on them later on, and also want to buy into a system of international law that is mutually beneficial, you do have states going along with the decisions of the ICJ and of courts at least some of the time. And at least some of the time, you have quite heated territorial disputes do end up getting resolved by the ICJ if two states are willing to bring it there in the first place. So it's not going to solve every problem, but it does solve problems. And there isn't really an alternative for how you would have done that would be peaceful. In that respect, I think international law is quite a useful thing. And the fifth thing that I want to talk about is language, which is international law gives us, it has given us, the language to describe certain wrongs that have happened. So there's a concept in epistemology, the philosophy of knowledge, called hermeneutical injustice. Dylan McCarthy, in particular, is a debater who quite likes to run hermeneutical injustice in debates. But that basically refers to the harm of not having the language to either communicate what has happened to you or to understand what has happened to you, and therefore to describe it to yourself. A fairly well-known example of it historically is the concept of sexual harassment, that being a kind of harm that happened to women for centuries, which they previously lacked the ability to put into words or to vocalize, which meant they sort of couldn't word it or conceptualize it to themselves, but definitely couldn't share it with others or talk about it absent the language to do so. Well, international law also solves a form of hermeneutical injustice by giving us the language to describe certain very severe kinds of wrongs. And all these concepts have very specific meanings, which also gives the use of those words weight. For example, war crimes have a very specific meaning, which is acts carried out during the conduct of war that violate the laws of war or international humanitarian law. So there is a very strict set of rules that you can point to being violated to say something is a war crime. Similarly, genocide has very specific meaning, which is acts committed with the intent to destroy, in whole or in part, a national, ethnic, racial, or religious group. Ethnic cleansing means rendering an area ethnically homogenous by using force or intimidation to drive out another ethnic or religious group from the area. And crimes against humanity are specific acts committed as part of a widespread or systematic attack directed against civilians. Those acts can include torture, rape, extermination, enslavement, forced displacement, but they are acts from a specific list committed as part of a widespread attack that was directed against civilians. Having that language, and that language having very specific and tight meanings, allows us to analogize between very severe injustices and explain exactly what is wrong about a given act. And in doing so, that can let us hold governments to account, even if only through accusations. So it might not be perfectly all the time that we can stop a government in their behavior immediately, but it does mean that we can at least use this language that does have a tight meaning to explain what they're doing wrong and accuse them of doing that kind of wrong. And what I would also suggest is because governments don't want to be accused of doing these things, it does give them an incentive to maybe not avoid doing terrible things all the time, but at least some level of optical incentive to seem like they're not doing those things. And then I would also say there are many cases in which it does encourage them not to do those things at all, or to try and avoid them and follow through the laws of war and things like that. I'm not saying this is a perfect system, but I do think that because states don't want to do the worst offenses and don't want to be accused of doing the worst offenses, they often take some level of steps to either cover it up or to choose a different path, unless their intent to do this vastly outweighs the harms or consequences of doing so. But I do still think there's a lot to be said for there being words that exist to describe the terrible things that a human being can do, and us being able to point to the specific ways in which that definition is met, the reasons that definition is met, and what that definition of being met means about how it compares to other things that have also met those definitions. So that's the thing that I think gives legal words and international crimes like this a very deep and significant meaning, and it's significant weight because they have such a specific meaning. Now, there are still some obstacles to international law. Primarily, I would say there are two of them. And I think they are ones that often come up in debates, but are still useful to know just in terms of being able to make those arguments yourself, and I guess also being able to prepare for those arguments as they arise. The first is state sovereignty. The second is the lack of enforcement, the fact that you can't physically force a country to follow an agreement or to stay agreeing to something that they previously agreed to or to follow the decision of the court. I'm just going to take a drink. 1 second. So, state sovereignty is the principle that every state has the exclusive right to govern itself without any external interference. Every state is free to make treaties with other states, and no treaty is binding on a state unless it has agreed to become a party to it. In most international organizations, with the exception of the IMF and the EU, which weight votes, the vote of every state is equal, because the idea is that insofar as they are free to make decisions for themselves, they are also equal to one another, and they have an equal right to say what kind of decisions should be made by international organizations. Under a very old treaty, which kind of like defines how treaties work, called the Vienna Convention on the Law of Treaties, a treaty that is procured by coercion, or that a state is forced into in that way, is automatically void. It doesn't apply, it doesn't have any salience, but it doesn't apply to that country or tie them to anything. The UN Charter explicitly prohibits the threat or use of force by one state against another, and every state is entitled to diplomatic immunity, where its diplomats and representatives are all immune to the jurisdiction of the courts of other states, because since they represent that state, they can only be held accountable by that state. Otherwise, as representatives of that state, holding it by, like, to account in another state by another state's courts would be, in a way, violating the sovereignty of the first state. But all of this is because of state sovereignty, and because international law doesn't allow for any state to be forced into anything against their will. And that's all well and good, except when it comes to good kinds of international law that we'd really like to see enforced, because we can't actually make states play along. In particular, we can't make them sign or ratify treaties that we have made. We also can't stop them from derogating or reserving certain rights. So derogation is in times of emergency, basically. You can partially suspend certain treaty obligations. One example is in COVID-19, when states had to restrict citizens' freedom of movement for the greater good. What happened was a lot of states derogated their obligation to uphold the right to freedom of movement because it was a public emergency. Reservations are basically a state declares at the time of signing or ratifying a treaty that they will be excluding or not agreeing to certain treaty provisions from the offset. So China made a reservation to the ICESCR, the International Covenant on Economic, Social, and Cultural Rights, which basically was a reservation to the right to form and join trade unions. They were like, no, it's fine. We're making a reservation. We'll interpret it in line with domestic law, which basically meant it didn't get upheld at all. But we can't stop states, given that they're opting into a treaty, from doing that to certain rights and saying that certain aspects do not apply to them. And what we also can't do is stop them from prioritizing their own interests or opting out of international law, even though they've previously agreed to it. One example of that would be the Philippines, which was a party to the Rome Statute from the beginning, which is they were an ICC member state. The ICC was supposed to apply to them. In 2019, the ICC issued an arrest warrant for then President Rodrigo Duterte over his conduct during the Philippines' war on drugs. He immediately withdrew the Philippines from the ICC, and it hasn't been a member state of the ICC since then. Now, they managed basically to arrest him. I think the Philippines ended up handing him over when he wasn't president anymore. Last year, that's a bit imperfect though, because while it is over things that happened while the Philippines was a member state, the Philippines wasn't a member state at the point that they did actually end up arresting him. But basically, it wasn't possible to stop a state opting out of the Rome Statute and opting out of ICC jurisdiction because they didn't like a certain kind of arrest warrant the ICC had issued because it wasn't in their interests. So there is a harm to the fact that we can't stop states or we can't make states behave a certain way about treaties. We can't make them sign it. We can't stop them from signing it with conditions we don't like in a lot of cases. And we can't stop them from prioritizing their own interests and opting out when it is inconvenient for them. I will move on to the second, but Dan, you've got your hand raised.
Yeah. So this idea of being coerced into like certain treaties or like certain terms within those treaties, how exactly is this like conceptualized in that whenever I sign a treaty, I'm presumably doing that because I want to gain some benefit from that. So most obviously in terms of peace treaties, clearly there's the implicit threat there of if you don't sign, I'm going to continue waging war on you. Is that not like coercion? And then how do we conceptualize this?
This is maybe a slightly more philosophical question that is the purpose of this talk. I would say coercion generally is when you make the utility of not doing something so disutile that a person will always choose to do the thing, even though doing the thing is also negative utility or is also not in their interests. So I was at a workshop recently where a good example of this was like, if I really don't like soup, but I'm presumably a child for this. So you give me a choice as whether or not to have soup. If I don't have soup, 0 utility. If I have soup, -1 utility. I don't like soup. I don't want to do it. But my parents say that they will restrict my access to my Xbox if I don't have soup because they want me to be big and strong. So they say if you don't have soup, then you don't get your Xbox the whole weekend. That is, for me as a child, worth -3 utility, or it is at least worse for me than the cost of having soup. Which means even though having soup isn't in my interest, it's something that is negative utility for me. It's less bad than not having soup now because the cost of not having soup has changed. And so we would say coercion is a situation where a state is signing something not because the thing is in their benefit or in their interest, but because the cost of not signing it has been raised such that whatever cost there is to signing it is now less than the cost of not signing it has been made to be artificially. To be then specific as to what I think it probably looks like, I would say economic coercion of a kind of like threatening to withhold trade or withhold trade that's very critical to that country, threatening some kind of economic sanctions, which are going to be very harmful to that country's economy, threatening invasion, probably, threatening some kind of interference with their political system would also meet this criteria. But generally, anything that takes away a state's ability to choose to opt into a treaty would constitute coercion. I would say that the fact that it is unlawful is kind of why it doesn't happen much. So the reason I don't have many like concrete examples for you is that because it is not allowed, it hasn't really happened for the most. I would say I probably can't say at all, but I would say for the most part, I don't think it's happened in many instances, and that's because it's unlawful. The second example then that we're talking about in terms of what can be an obstacle to international law working is that there is no enforcement to those things. There maybe are 2 examples to talk about here where there might be some enforcement, but not a lot, and it's not great. The first would be the International Criminal Court, as I've said, does issue arrest warrants, but the arrest warrants only work if ICC member states comply. So, for example, there's been an ICC arrest warrant out for Vladimir Putin since the start of the war in Ukraine. You might notice Putin is not locked up in The Hague right now, nonetheless. And so he visited Mongolia last year. Mongolia is an ICC member state. And in theory, that means that Mongolia was required by treaty obligation to immediately arrest him and send him to the Hague. But they didn't, which means that while this exists and while these obligations are out there, you can't make a state follow the arrest warrant, which means that there's sort of some cost to doing so. I am nearly done, Dan. So like in the next 5 minutes, I promise. And that means also the IC doesn't have its own police force to round up war criminals. There have been some times where debates have been set to try and solve that particular problem. So the Sydney Mini Grand Final last year, Sydney Mini being a very big Australian comp that exists, was this House would establish an international force to arrest those indicted by the International Criminal Court. Closing opposition 1, which may or may not be informative. But that is to say, debates can be set to try and solve these problems, to say, we'll give the ICC an international police force. That'll let them round up their war criminals, so it's fine. But the problems do exist, and it's good to be cognizant of those things. The second example to maybe talk about is the ICJ, which is an example where they don't have their own ability to really enforce the things they decide. So they can say, you have to give that peninsula to that other state, or you have violated this international law, or you owe this other state a huge fine for what you have done to them. And there are many cases where states have followed those things, or where just declaring the violation of international law has had such a huge effect in terms of language, and effect in terms of what that means to violate such an important thing in international law, that it has meant something, and or given victims themselves or something like that. But it doesn't mean that states are tied to follow those things. With the ICJ in particular, they have the abilities that sort of, if you don't obey the things they do, they can go to the UN Security Council, and the UN Security Council could make you do it. And they do have the power to decide things, which is maybe quite rare for UN organs. But what the UN Security Council also has is the primary 5 vetoes, where Russia, China, France, the UK, and the US all have permanent seats on the Security Council, and all have the ability to veto decisions made by the Security Council. So even though the UN Security Council could, in theory, order sanctions on a state that doesn't follow these things, or could order they can order military actions or legitimize military actions if you don't follow these things, because there's something political afoot between, the US and Russia, or the US and China at any given time, or because often the states affected by this are allies to one of those 5 states, you can either have just the threat of a veto from one of those states means that you won't decide such a harsh punishment or such a harsh response, or the actual ability to veto means that it does create a stumbling block for the ability for the Security Council to get anything done in those areas. Which means even though, kind of like the ICC, there is in theory a way for something to happen and make sure that people follow these things, there's not in reality a very concrete way to make sure that the choices and decisions of these courts are actually enforced. So in some sense, there's pros and cons. There's some ability to get things done. But on the other hand, the maybe more pessimistic view is that you often can't enforce the decisions. And that can often be quite disheartening and also quite harmful in the ability to kind of, get things done and make sure these decisions are actually listened to. That's all I've sort of prepared for this. I have a motion for the debate that will follow. But I might just ask, I'll turn off the recording for this bit, but thank you so much for having me. I'll stop recording now.